Thank you so much, Janet. Hello, everyone. Thank you for joining us today as we explore such an important topic. As Janet's already confirmed, my name's Ranjit O'Mahony. O'Mahony is quite a difficult surname to pronounce, so don't worry about it, Janet. Nobody can ever say my surname. And as Janet's confirmed, I'm a Senior Employment Solicitor at Morrish Solicitors based in Leeds. At Morrish, we act for 34 trade unions and associations that range from some of the largest trade unions in the country to some of the smaller bespoke professional associations. The members that we represent come from all walks of life and industries, from education and healthcare to transport and manufacturing. We only act on behalf of employees and workers. We never act on behalf of employers or insurance companies. So in my almost 20 years of being an employment lawyer, I have dealt with a huge number of sexual harassment claims, ranging from one-off acts of harassment to harassment that have continued for a really long time, often several years. There's been significant strides within the developments within sexual harassment legislation, including some landmark decisions, but there are challenges that still remain. And those are some of those things that I want to talk to you about today, about these developments and why I don't consider them to be far-reaching enough to provide the protection that we need. So just to kind of go back to basics, sexual harassment as a concept was first developed by grassroots women's rights activists back in the 1970s in North America, and it spread to the UK by around about the mid-1970s. The first legislation that we had in the UK was the Sex Discrimination Act 1975, which made it unlawful to treat a woman less favourably than a man on the grounds of her sex. But the Sex Discrimination Act did not specifically mention sexual harassment. By the 1980s, a campaign was in full swing to raise awareness of the extent and seriousness of sexual harassment in the UK and to change the law. But it wasn't until 11 years later, in 1986, with the case of Strathclyde Regional Council versus Porcelli, which took 2 years to get to court, where there was a ruling that sexual harassment amounted to discrimination under the Sex Discrimination Act. So despite it still not being explicitly set out in the legislation, we've had developments in the case law that gradually defined and recognised sexual harassment to be actionable over the years. But it took until 2010, with the introduction of the Equality Act, that it became a little easier to address issues of sexual harassment. So the Equality Act, for those who aren't familiar with it, is a comprehensive piece of legislation that consolidated and replaced earlier anti-discrimination laws, finally setting them all out in primary legislation that sexual harassment is prohibited. So the pace of change has been painfully slow. It's taken 35 years from 1975 to 2010 to specifically set this out in legislation. And I'm going to talk to you a little bit about the legislation and what it actually says. Section 26, subsection 2 of the Equality Act provides us with the following definitions. So sexual harassment is defined as unwanted conduct of a sexual nature that has the purpose or effect of violating someone's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for them. Now, employers can defend a claim for sexual harassment where they can show that they've taken all reasonable steps to prevent the harassment. And that's what we refer to as the statutory defence under Section 109 of the Equality Act. The Equality Act originally, when it was first introduced, also introduced the concept of third-party harassment under Section 40, which is where employers could be held liable for harassment by customers, clients, suppliers, where they'd failed to take action, but only if it had occurred on at least 2 previous occasions. So the inclusion of third-party harassment demonstrated a significant recognition of the realities faced by many working in public-facing roles. We then took a step backwards in 2013, when the previous government watered down the protections available for third-party harassment by repealing Section 40 of the Equality Act. So fast forward 11 years forward, and the new Labour government has introduced further developments on the law of sexual harassment by introducing the Worker Protection Amendment of Equality Act 2023. So this act introduced a new preventative duty, which came into force just the back end of last year, on the 26th of October 2024, which requires employers to take reasonable steps to prevent their employees and workers from being sexually harassed in the course of their employment. The Equality and Human Rights Commission has the power to take enforcement action where there's been a breach of a duty, and the Employment Tribunal has the power to award an uplift up to a maximum of 25% for any compensation awarded where a claim for sexual harassment is successful and there's been a breach of the preventative duty. So the recent changes in sexual harassment are also supported by various other resources, including the Equality and Human Rights Commission's technical guidance, the 8-step guide on preventing sexual harassment at work, the ACAS guidance, and there's also specific resources for employers in the hospitality industry. Now, you would think that with this new preventative duty and all the supporting guidance would strengthen the protection available. However, the legislation simply does not go far enough. It was originally intended to introduce a duty that employers take all reasonable steps to prevent sexual harassment in the workplace, but this was watered down to just reasonable steps. So there's talk in the Employment Rights Bill, which is currently going through Parliament, that the Employment Rights Bill is going to change that, and it's going to require employers to take all reasonable steps to prevent sexual harassment and also reintroduce the much needed protection on third-party harassment. There's also been discussions about making complaints of sexual harassment to amount to a public interest disclosure, otherwise known as whistleblowing, and also to extend the time limit for bringing harassment claims from 3 months to 6 months to reflect the trauma that the victims often face. These changes would be welcome, but more needs to be done. Sexual harassment is often directly related to the gender dynamics of workplaces and affects those most vulnerable, particularly those in precarious employment and who are often too afraid to speak out. In my experience, it's often the case that non-disclosure agreements, NDAs, are used to silence victims of sexual harassment and shield the harasser. Employers are concerned with their reputation, and again, in my experience, most of these cases settle before reaching a tribunal to avoid any reputational damage for the employer. So just to clarify, although the compensation for discrimination claims, including harassment, is uncapped, and although the financial consequences can be significant with these types of claims, this doesn't appear to be sufficient to prevent these types of claims. So campaigns like End Not Defend are vital to raise awareness, to bring sexual harassment to the forefront, and once again show that this is still an issue that needs to be addressed. So where are we today? The Women and Equality Select Committee report back in 2018 called for stronger enforcement mechanisms, mandatory reporting for employers, and the reinstatement of third-party harassment protections, all of which are still not in place. It's clear from the claimants that I speak to, many of them do not report the harassment for quite some time. They're hoping it's going to stop. Many are in fear of repercussions or retaliation from their employer, or fear that they won't be believed. Many are simply just too afraid to speak out. With strict time limits in place for tribunal claims, they often find that their claims fall outside the time limits, severely impacting their access to justice further. So changes are desperately needed, as the law simply does not go far enough to protect those who are most vulnerable. However, legislation alone can't shift these deep-seated attitudes, and for too long, it's an issue that has been brushed aside or endured in silence. So sexual harassment undermines equality, dignity, and safety. A cultural change is needed. Education and awareness are essential to fostering this change. This is why this campaign is so vital, to create workplaces where dignity and equality are non-negotiable. By addressing both the symptoms and the root cause of sexual harassment, we can create a future where everyone thrives.